Tom Abbate, and now we're going to talk about burglary. In Texas, there are two main categories for burglary. There's burglary of a building, which is typically going to be a state jail felony, and then there is burglary of a habitation, and that is going to be a much higher level felony, typically first degree. Now, for burglary of a habitation or of a building, that's just typically you break into a building that no one lives in. So, the CD store or Best Buy, it's closed down. You break in the middle of the night. You probably steal some stuff. That is considered a much lower offense because the risk to any one person is substantially lower. Typically, it's going to happen when the building is shut down and no one else is there. If it's otherwise, it's probably going to be categorized as a robbery, but that's a different video. With burglary of a habitation, these are treated as higher level offenses because there is a risk to the occupant of that home. Essentially, you are alleged to have broken into someone's residence, and if they're there, obviously that's going to become a dangerous situation. Now, the things the state has to prove in order to prove a burglary is that you entered a home when you did not have the right to do so, and you did it for the purposes of either committing another felony, typically aggravated robbery, murder, potentially assault, sexual assault, or kidnapping, and or a theft or a regular assault. Now, typically, if they're alleging murder, you're probably just going to get pushed up into capital murder if you actually managed to kill someone while you were in there. But that is one of the ways they can get to burglary. Most of the time, they're looking at, what was your intent while you were in there. For instance, even if it's just to steal something, it's still going to be treated as a high-level felony because it is someone's home. And you've got to remember, this is Texas. Many of us are armed, especially within our homes. And so there's a good chance that when you kick in someone's door, if they're there, they're going to get their gun, and now someone's life is on the line, whether it be the person entering the habitation or the person defending that habitation. Now, the other thing that you've got to keep in mind is that they don't necessarily have to prove that you actually did commit the underlying offense. If the state can prove that you intended to commit the underlying offense, that is sufficient. So, for instance, I kick in the door, I'm going to go and beat up Bob while I'm in his house. I don't actually manage to beat up Bob, though. He gets the drop on me, comes around the corner with a baseball bat and hits me over the head. But I've made some statements about this is what I was going to do. Well, that's enough to get you for burglary, even though I didn't manage to assault Bob. This can cause some problems, though, when you actually do commit the underlying offense. Normally, under double jeopardy, you can't be punished twice for the same conduct. With burglary, it's a little bit of an exception because they can charge you for entering with the intent to do something, and they can charge you with the fact that you actually committed that underlying offense. You don't get two burglary charges, you just get the burglary for intent to commit assault and the assault. And those have been deemed to be separate offenses because one is focused on the intent, the other one is focused on the actual conduct. This is something that really needs to be dealt with, though, by your trial attorney because they need to point out to the jury that the jury has to distinguish between those two offense levels. A lot of times what the court and the state will try and do is they'll put in a general verdict for burglary. We just find him guilty of burglary, and they'll tell you that you can get there with the intent to commit the underlying offense and by actually committing the underlying offense, and you'll have another charge for that underlying offense. This is problematic because when you get the general verdict, you don't really know what basis the jury decided that you were guilty of burglary, and so you potentially could have some double jeopardy issues. But these double jeopardy issues need to be, firmly founded on the record and identifiable, as opposed to presumed double jeopardy or, imagined double jeopardy. And so it's very important that any trial attorney you hire is aware of this and is arguing to the court that they need to have a specific reason as to, on the judgment, or on the verdict form, as to why they are finding you guilty of burglary, whether it's with intent to commit the underlying offense or having actually committed. Because if you can nail that down, then there's only one way they can convict you of both, which is to find that you intended to commit it and then did commit it. And so make sure that you bring this up with your attorney and that you've hired the right counsel.